Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a big docket for you today. First, closing arguments are finally going to begin in the Karen Reed case tomorrow morning. The Richard Allen case also has another hearing date set. That ought to be fun. New information on the Justin Timberlake DUI case. Julie Chrisley gets some relief from the appellate courts. A child actor finds himself in some trouble. Yeah, this guy is a really bad dad. And when someone says we are going to all die tonight, what's going through your head? Well, I'll tell you what happened. We have a story of a cop gone bad. The United States Supreme Court says domestic abusers can be barred from owning a gun, and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. You're going to want to hit the notifications. Why? Because if you subscribe and you hit that little notification, you're going to get notice. Like for tomorrow when the Karen Reed trial and the closing arguments come up. You don't want to miss it. All right? All right, before we get to the docket today, we have a new sponsor, U.S. Gold Trust. Now, I don't know if you've ever bought gold, but it's pretty exciting, okay? You get these little gold bars, and the beautiful thing is you know what you're buying and you know what the value is, and it's probably not going to change, and it's probably going to go up. But you got to make your own decisions. But with the direction of the economy being uncertain, investing in precious metals such as gold and silver is the way to go. Precious metals don't lose value like the dollar and acts as a barrier against inflation. Investing in precious metals can be a very smart way to diversify your portfolio, reduce your overall risk, and protect your wealth in the long run. Now, I buy gold, and you should think about doing it too. You can find the link in the bio below and look at protecting your retirement. Now remember, when you go to the link, they're not going to try to sell you anything. They're going to send you a report on why you should do it. Take the time, check it out. It's your decision. Take your time, look at it. If it's the right decision for you. All right, so let's go ahead and get to the docket for June 24th, 2024. And first on the docket, Karen Reed. That's right, the longest hit and run / leaving the scene of an accident resulting in death trial in the history of mankind is almost done. I think we're on day 30 today. Anyway, the defense in the Karen Reed murder trial rested its case a little after 1 p.m. today. Closing arguments will begin Tuesday morning at 9 a.m. East Coast time. That means it's 7 a.m. I am going to do my best to join you. I'm already up, but I'm going to do it from home, I believe, so that we can get all of the closing arguments there. All right. Now, as you may know, Miss Reed of Mansfield, Massachusetts, has pled not guilty to charges that include second-degree murder in the death of John O'Keefe, her former Boston police officer boyfriend, former because he's now deceased. If you've been watching the case or been following the last 30 days of the gavel-to-gavel coverage that we've been bringing to you, prosecutors have alleged that Miss Reed backed over O'Keefe with her Lexus SUV and left him for dead in a snowstorm outside of 34 Fairview Road in Canton, Massachusetts, back in January of 2022, after, of course, a night of heavy drinking by all involved. Now, the defense aim was to prove that O'Keefe was murdered by someone inside the home where he went for this after party after the bars had closed, and then he was tossed into the snow to make it look like, that's right, Karen Reed did it. So wait for this, 68 witnesses. That's how many witnesses have been called. And like I said, the prosecution rested their case on Friday afternoon, and the defense began their brief presentation to the jury after the court denied the motion for judgment of acquittal, and therefore the witnesses were very quick for the defense. Not unusual. When you have 68 witnesses called by the prosecution, you're going to get just as much evidence that you need from those witnesses. There was a biometric person that testified this afternoon, basically saying, the speed in which somebody would have been hit, etc. Oh, and those bite marks are from an animal, even though there's no canine DNA on the injuries. Pretty straightforward, pretty simple. But that particular doctor that testified today did state that the injuries on O'Keefe were consistent with a canine. The theory being that he was somehow attacked inside, the dog got him, you name it. Anyway, we'll all find out tomorrow how all the pieces fit together for the closing argument. Join us, 7 a.m. Mountain Time. All right. Next on the docket, Richard Allen. That's right. We have a hearing coming in the Richard Allen case. When I say soon, nothing's gone soon or quick in this particular case either. And hey, it's going to be fun. So the Carroll County Special Judge Francis C. Gull will have a Richard Allen-related hearing beginning late next month. Now, the filings in the circuit court reveal that several motions concerning Allen's legal case are expected to be heard over 3 days. The hearing will begin on July 30th and go through August 1st and start at 10 a.m. each day. Now, Mr. Allen is accused of killing 13-year-old Abby Williams and 14-year-old Libby German near the Moden High Bridge in Delphi back in 2017. That's Delphi, Indiana, to be specific. Anyway, since he was arrested back in October of 2022, there have been a number of back-and-forth legal exchanges and claims, as well as the changes in dates between Allen's attorney and the state. Anyway, the 3 days of hearing are expected to cover various motions filed over the past few months between the prosecution and the defense. This includes evidence disputes, including a request by Mr. Allen's attorneys to dismiss ballistic evidence as well as claims surrounding Allen's status in the jail. Now, as you may recall, back in April, Allen's attorneys claimed that Allen was not read his Miranda rights before his interview in October of 2022, and the attorneys also claimed the other highly unusual police behavior toward Mr. Allen, including missing portions of footage from the interview and keeping Allen in a small windowless interrogation room for more than 2 hours before he was allowed to leave. Well, Mr. Allen's case is scheduled to start on October 14th. Obviously, this comes after the case has been pushed back a number of times. Like I said, October 14th through November 15th is the date. We'll just have to wait and see. I can tell you how these motions will be ruled upon. Here you go. My prediction, my crystal ball. Defense motions denied. The motions filed by the prosecution, they are hereby granted in whole or in part, but they will be granted. Defense, you get nothing. Zilch. Nada. Nothing. Nothing. Zilch.
You get nothing. You lose. Good day, sir.
You get nothing. Right here. Clear as day. Nothing. Next on the docket, Justin Timberlake. Man, this case just getting worse for Mr. Timberlake. And yes, you shouldn't drink and drive. We'll give everyone that. He should have walked home. He should have taken an Uber. He should have had a friend drive who was sober. Clearly, he should not have driven. And no one is going to condone drunk driving at all, because it is probably one of the most preventable crimes that can actually take place, because you shouldn't do it. Everybody knows you shouldn't do it. There are some new details about Mr. Timberlake's arrest last Tuesday in the New York Hamptons, including a warning that Justin Timberlake probably was given and ignored. So there are some reports out there, and we got to take these with a little bit of a grain of salt because, people want to speak on anonymity, but sometimes those do come out to be true. Anyway, take it for what it's worth. I give you the caveat, the warning that this is not a lot of people going directly on the record. But there are reports alleging that Timberlake was warned not to drive by the same police officer who wound up arresting him, and that police might have been tipped off to the singer getting behind the wheel. Now, as you may recall, we brought it to you on our live program last week that Justin Timberlake was pulled over after he ran a stop sign and veered out of his lane while behind his 2025 BMW X7 about 12:30 a.m. on June 18th in Sag Harbor after a night out with some friends. Where were his friends? Really? Should have driven him home or said you're not driving. Anyway, Timberlake was stopped and advised not to drive in his condition by the Sag Harbor police officer, this guy by the name of Officer Michael Arkinson. He's doing his job, even giving the guy a break. Hey, man, if you're not going to, maybe you shouldn't be drinking. I'm good. But as soon as he drove away, the officer couldn't ignore it anymore. The officer did the right thing. Anyway, apparently, as we talked about before, the officer didn't recognize who he was, but he tried to give him a break, and Timberlake blew it. The cop tried to give him a break because he didn't pose an immediate danger, probably because he wasn't behind the wheel of the car. Anyway, the police officer believed that that was the end of it, and that Timberlake would get a ride home before, again, seeing Timberlake behind the wheel several minutes later. Now, this source has stated that Timberlake was a dumb ass. Anyway, the sources claim that Timberlake was a dumbass and thinking that he could afford a driver. How's that for a sense of entitlement? Anyway, when the officer did stop him, he determined that Timberlake was, in fact, intoxicated. There's another story by a well-respected restaurateur in the area that believes that it was the hotel that contacted the police after seeing Mr. Timberlake partaking of the adult beverages. Apparently, a reporting party had said that Justin was having a lot of drinks, and they told the cop to watch him to see if he was going to drive. Probably when he went over and talked to him, tried to give him a break, and Timberlake said, I can do whatever I want. And anyway, he got pulled over. And when he was pulled over, guess what? He had the bloodshot, watery eyes, slurred speech, and a strong odor of an unknown alcoholic beverage that was emitting from his breath. He was unable to divide attention. He was slow in his speech, unsteady on his foot, and he performed poorly on the standardized field sobriety tests, according to the arrest reports, which means, ladies and gentlemen, that is standard stuff. You could probably have the police officers, they used to literally, I think, have a big old stamp, with the ink, boom, put it there. Standard language on every test. Anyway, the test included the walk heel to toe in a straight line and turn and retrace your steps, and then the one-legged stand, which Mr. Timberlake failed miserably, apparently. Anyway, Timberlake told the officer that he had, one martini, and he was going to follow some friends home. And after being arrested, guess what? He went to jail, and he refused the breath test. Probably the best thing he could do for the case against him is not to have the corroborating evidence that he was in fact drunk. Of curious note, his occupation is listed as professional and self-employed. He was released from the police station after a bond hearing where he was given a personal recognizance bond. He was arraigned on one count of driving while impaired, running a stop sign, and failure to stay in a single lane. His next court date is July 26th. Next on the docket, Julie Chrisley, one of the top two most annoying people on TV. Yes, the first being her husband. Anyway, she's got some relief from the appellate courts. Anyway, there's a lot of people saying that her whole case is thrown out. No, her case wasn't thrown out. Her sentencing was thrown out. A 3-judge panel on the 11th Circuit Court of Appeals ruled that the judge in the 2022 trial miscalculated Julie's federal sentencing guidelines. So, therefore, the 3-judge panel upheld Julie, Todd Chrisley's, and their accountant's Peter Tarantino's conviction. They found there was insufficient evidence to support the ruling that Julie was involved in the entirety of the bank fraud scheme. And therefore, since the judge determines there was insufficient evidence to prove she was involved in the scheme, which began in 2006, before 2007, obviously. Anyway, the court noted, did not identify the evidence it relied on to hold Julie accountable for losses incurred before 2007, and the court cannot independently find it in the record. The judge stated in their ruling, and so they vacate Julie's sentence and remand solely to the district court to make the factual finding and calculations necessary to determine loss, restitution, and forfeiture as to Julie and to re-sentence her accordingly. Like I said, her case wasn't completely thrown out. The sentence was. That means the judge gets to go back, find the evidence that he apparently didn't note in the record, and he could impose the same sentence or he could reduce the sentence based upon his discretion under Rule 18 United States Code 3553A, and as well as considering all of the factors and the considerations for punishment, rehabilitation, the sentences should not be so vastly different from others, and obviously to provide for punishment and rehabilitation, and that sentence to be no greater than reasonably necessary to assure those principles of sentencing, ladies and gentlemen. So Miss Chrisley's case will now be handed back to the lower court to determine how her sentence will be adjusted. Now, Todd's 12-year sentence, which was previously reduced to 10 years in September, has not been affected in any way. And the ruling comes 6 months after Julie and Todd Chrisley, the most annoying man on whatever it is, reality TV, who reported to their respective prisons back in January 2023, received a $1 million settlement from the state of Georgia after suing the former special investigator Joshua Waits for misconduct in the handling of their investigation. The settlement was awarded in January after a September 2021 report from the Atlanta's Office of the Inspector General supporting Todd Chrisley's claim that he was unfairly targeted for investigation due to his celebrity status. The Office of the Inspector General investigation found photos of the lead investigator posing on Chrisley's seized furniture and messages bragging about having done so. The report's finding also said that the investigator's office filed an improper request with the United States Treasury Department to access the reality TV star's bank accounts. Ooh, can't do that. Anyway, despite the allegations of misconduct back in June of 2022, Todd and Julie were found guilty of 12 counts in federal court after trial, including charges of wire fraud, conspiracy to commit bank fraud, and conspiracy to defraud the United States. They began their sentences in 2023, which were each shortened in September, with Julie's sentence dropping to 5 years and Todd's changing to 10. Now this means Julie may get a little bit less. Who knows? She could be home soon and back on TV in any time. Next, a child actor is now in trouble. I guess I should say former child actor is in trouble. The Sandlot actor Thomas Gyrie was arrested earlier this month after allegedly bashing the windshield of a Jeep with a 35-pound dumbbell and going to a man's door with a knife, according to police reports. Now, Gyrie was charged with third-degree assault and battery and malicious injury to personal property, and he was booked into the detention center back on June 2nd and released on a $1,000 bond the following day. Now, Gyrie is best known for his role as Scott Smalls in the 1993 movie The Sandlot. He was 11 years old at the time, and he was also featured in other films such as Lassie, The Last Home Run, Wrestling with Gators, Black Hawk Down, and Justice. Now, the police responded, like I said, on June 2nd to investigate this trespassing disturbance call. And when the officers arrived, the police report said that Mr. Gyrie was in the middle of the road and asking about his wife's safety. Now, the owner of the Jeep then reportedly shouted to Gyrie, "Really? My window's been shattered?" And anyway, Gyrie responded, "That sucks, man. I'll pay you back. I'm sorry. I'm going to get you back." Gyrie later admitted to breaking the windshield. According to police reports, he said, "I did it. I'm sorry, man. I'm coming back to get you. I'm sorry, brother. I'll pay you back." The owner of the Jeep told police that the window was damaged with a 35-pound dumbbell weight before approaching his door with the knife, and it's unclear why the dispute started. Okay, some people would say this next guy is just a bad dad or maybe a monster. Please meet Edric Lamar Davis. He is now facing the death penalty for the first-degree murder felony charge and aggravated child abuse. He is accused of beating, wait for it, his 6-week-old son to death. Now, he first claimed, Mr. Davis did, that he didn't know what happened to his newborn son, but later admitted to police that he hit the infant in the back of the head multiple times with his knee. The morning of the baby's death, the police reports say that the baby's mother woke up, fed the baby, and left Davis alone with him for about 15 minutes while she took a shower. When she got out of the shower, the baby wasn't breathing, and there was apparently formula coming out of the child's nose. Well, guess what? Mr. Davis did make a written admission and actually wrote an apology when he was being interrogated by the police and said that basically, hey, I just lost control due to distress and was not in the right state of mind when he beat the baby with his knee. Well, there's more, ladies and gentlemen. The autopsy of that 6-week-old child found multiple injuries right before his death due to blunt force trauma and other older injuries that were in the state of healing. 6 weeks old or earlier? Are you kidding me? Anyway, those prior injuries included rib fractures and bruises on the baby's neck, which investigators say that it indicates 2 earlier incidents of abuse. I don't know, ladies and gentlemen. 6 weeks old, special place in hell for that individual, I do believe. Now, we'll give him the presumption of innocence, but he did confess to doing it, so I'm not sure. Maybe we'll have a trial because it'll be the death penalty case. Or I don't think he's going to get the death penalty, but he's going to go spend a lot of time in prison. I'd say next 40 to 60 years ought to do it. I'm okay with that. Anyway, what if somebody said, hey, I think we're all going to die tonight? What would you do? Well, I know what a jury did. They convicted J.C. John Chabot of attempted murder, domestic battery with the use of a deadly weapon, causing substantial bodily harm, and battery with the use of a deadly weapon. Now, the police officers with the Sparks Police Department responded to Wolverine Way back in January of 2023 after one of the victims called 911 to report that he had been injured and that the defendant's fiance had been shot. When the officers show up, guess what they find? They find Mr. Chabot outside a travel trailer on the property as they arrive, and despite repeated commands to stop, Mr. Chabot ignored the police and went inside the trailer for a few moments before exiting once again. The continued commands to stop by the police and get on the ground were completely ignored, and Mr. Chabot was hit with a taser by the police officers. Now, once Mr. Chabot was in custody, police entered the trailer where they found, guess what? His fiancée suffering from a gunshot wound to her face. The injury also included several facial fractures, you think, including her nasal cavity and jaw. Now, the landlord, who was also injured, was hit in the head by Mr. Chabot with the firearm, incurring lacerations and requiring some stitches. Now, during the trial, it was argued by the district attorney that Mr. Chabot intentionally lured both victims back to the property that evening. He then watched them enter the trailer, followed them with the firearm, and stated, "All of us are going to die tonight." Chabot then shot his fiancée and hit the landlord over the head with his gun. The prosecutors argued then that the evidence indicated Chabot intended to kill both victims and himself, but luckily the other man was able to wrestle the gun away and run out of the trailer. Now, Mr. Chabot's fiancée survived her injuries. And, after being convicted, Mr. Chabot is set to be sentenced on August 19th. He faces a maximum sentence of 60 years. That maximum penalty seems a little light to me. He's probably going to get closer to 60 than he is to, let's say, probation. You shot somebody in the face, Mr. Chabot. Are you kidding me? Your fiancée, the woman you're supposed to love, the one you wanted to marry and spend the rest of your life with, and you shoot her in the face? Unbelievable. Next, a cop gone bad. A former Las Vegas police detective was found guilty of murder late last week. The jury returned a guilty verdict against former Las Vegas Metropolitan Police Department detective who shot and killed her ex-son-in-law back in 2019. Now, Pamela Boudreaux was convicted of murder with the use of a deadly weapon. Boudreaux surrendered to police after the shooting, and when she said, "I shot him." Anyway, Sean Babbitt was on a court-approved visit with his child, according to the police documents. His ex-wife and son were upstairs while Boudreaux were downstairs. Prosecutors said Boudreaux shot Babbitt at least 10 times. That ought to do it. Sentencing is scheduled for August 20th, where the former detective could receive 20 to 50 years in prison, 20 years to life in prison, or life without the possibility of parole. For the murder charge. The deadly weapon enhancement could add another 20 years. Now, since Detective Boudreaux is 60 years old, it's all going to be a life sentence. Now, the former detective's defense team had argued that Babbitt was a danger and a sexual deviant. Obviously, the jury didn't believe that. Now, if she had maybe Mr. Boudreaux in the deviant act, the jury would have been a little more sympathetic. But just to shoot the guy 10 times, that's a tough one to sell, ladies and gentlemen. The law doesn't really go for that. Anyway, she's going to remain in custody, and her $1 million bond that she posted has been released. Next, a little Supreme Court news. Now, there's going to be a couple of big cases coming out of the Supreme Court here real soon, ladies and gentlemen, and they're already gearing up for the next session. Now, if you're truly just a geek, right? Supreme Court stuff, I think is just absolutely fascinating. So anyway, there was an issue of whether laws could prohibit somebody with a domestic violence conviction or factual basis from possessing a firearm. Now, that was what turned the entire domestic violence DV world upside down if that was not the case. There were laws passed, 30 plus years ago. The Brady amendments were basically, if you have a domestic violence conviction, you cannot possess a firearm. So let's get to it. So the Supreme Court last Friday upheld a federal law that bars anyone subject to a domestic violence restraining order from possessing a gun. Now, the vote by the Supreme Court was 8-1, and the court ruled that the law does not violate the Constitution's Second Amendment, which protects the right of the people to keep and bear arms. Now, the ruling came in the United States v. Rahimi, and that was the court's first Second Amendment case since it threw out New York's handgun licensing scheme nearly 2 years ago. Now, in that case, the New York Rifle and Pistol Association versus Bruin, the majority emphasized that courts should uphold gun restrictions only when there is a tradition of such regulation in U.S. history. The lower courts have struggled to apply this test that the court outlined in Bruin, and the court provided a little more guidance on Friday for them to use that going forward. Now, writing for the majority, the Chief Justice John Roberts emphasized that the court's Second Amendment cases were not meant to suggest a law was trapped in amber. Instead, he explained, courts considering the constitutionality of restrictions on gun rights must determine whether the new law is relevantly similar to laws that our tradition is understood to permit. Now, the lower courts have struggled to apply the test provided by the court, and so they provided a little more guidance. Now, writing for the majority was Chief Justice John Roberts, who emphasized that the court's Second Amendment cases were not meant to suggest a law was trapped in amber. Instead, he explained the courts considering the constitutionality of restrictions on gun rights must determine whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. So the challenge to the law came from a Texas man, Zachary Rahimi, back in 2020. A court in Texas entered a civil protection order against him after Rahimi dragged his then-girlfriend back to his car when she tried to leave after an argument. He pushed her into the car, causing her to hit her head on the dashboard. Now, Rahimi also fired a gun at a bystander who witnessed the incident, and the protective order specifically barred Rahimi from having a gun. A few months later, when Rahimi was a suspect in a series of shootings, police obtained a warrant to search his home. They found a rifle and a pistol, which prompted prosecutors to charge him with violating the federal law at the center of the case. Now, Mr. Rahimi argued that the law violates the Second Amendment, and in the wake of the Supreme Court's decision in Bruin, the U.S. Court of Appeals for the Fifth Circuit agreed. It explained that although the government was not required to identify a historical twin to the law, it had not provided the kind of well-established and well-representative analog needed for the law to survive. Anyway, the Supreme Court reversed the Fifth Circuit's decision, and Robert observed that some courts have misunderstood the methodology of our recent Second Amendment cases, and he cautioned against taking too rigid a view of the historical tradition required by Bruin. He noted that if courts looked, for example, only at what weapons were in existence in the U.S. history to determine whether the Second Amendment protects a particular firearm, it would only protect muskets and sabers, which is not the case. By that same logic, the Chief Justice noted, the Second Amendment permits more than just those regulations identical to the ones that could be found in 1791. Instead, the Chief Justice explained courts should look at whether the modern regulation being challenged is relevantly similar to historical regulations, and in doing so, he stressed courts should focus on the purpose of the regulation and the burden that is placed on the Second Amendment right to bear arms. For example, the Chief Justice writes, if laws at the founding regulated firearms used to address particular problems, that will be a strong indicator that contemporary laws imposing similar restrictions for similar reasons fall within the permissible category of regulations. When that principle is applied to the federal law, as here in this case, Roberts said the law passes constitutional muster. Surveying early English and American gun laws, he concluded that since the founding of the United States, firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. In particular, he pointed to two different kinds of laws, English and U.S. history laws, that gave courts the power to require individuals who were believed to be a threat to post a bond, and laws that provided for the punishment of individuals who had threatened others with guns. Now, when those two sets of laws are viewed together, Justice wrote, they confirm what common sense suggests. When an individual poses a clear threat of violence to another, the threatening individuals may be disarmed. So, even if the federal ban on possession of guns by an individual subject to domestic violence restraining orders is not identical to those two kinds of laws, Robert continued, it is for purpose of this test sufficiently similar. Among other things, Roberts noted that the ban, like the other laws, was intended to reduce demonstrated threats of physical violence, and it only applies after a court has concluded that the individual represents a credible threat to someone else's physical safety. Roberts also devoted a paragraph describing the errors he saw in the Fifth Circuit ruling. First, he said the Court of Appeals interpreted Bruin to require a historical twin rather than a historical analog, but because Rahimi's challenge to the law's constitutionality was a facial one, that is, he argued that the law is always unconstitutional, the Court of Appeals should have focused on the scenarios in which the law was most likely to be constitutional, rather than, as it did, on hypothetical scenarios in which the law might raise constitutional concerns. Anyway, that error, Robert persisted, left the panel slaying a straw man. Although the ruling was a victory for the government, the majority rejected the federal government's argument that Rahimi could be deprived of his right to have a gun because he is not a responsible citizen. Responsible, Robert wrote, is a vague term. It's unclear what such a rule would entail, and there is no support of such a rule in the Supreme Court's Second Amendment cases. Now, Justice Clarence Thomas, the author of the court's decision in Bruin, was the lone dissenter, and unlike the majority, he believed that the federal government had not provided any evidence that the ban issue here is consistent with the national historical tradition of firearm regulation. The early laws to which the majority points to support the holding that Thomas contended are in reality too different from the ban here to serve as a historical analog. Rahimi's case, Thomas concluded, is not about whether states can disarm people who threaten others, because states already have a way to do so by charging the person making the threat with an aggravated assault. The real question, he suggests, is whether the government can strip the Second Amendment right of anyone subject to a protective order, even if he has never been accused of or convicted of a crime. He asserts that it cannot. Now, although 7 justices joined Judge Roberts in rejecting Rahimi's challenge, several of them wrote separate concurring opinions and to add their own views on the court's latest elaboration to the history and tradition test. Justice Sotomayor, joined by Justice Elena Kagan, who both dissented in Bruin, again voiced her belief that Bruin was wrongly decided, but Friday's interpretation on the Bruin test, Sotomayor contended, was preferable to the one outlined by Thomas in his dissent. The former, she argued, permitted a historical inquiry calibrated to reveal something useful and transferable to the present day. By contrast, she wrote, Thomas would make the historical inquiry so exacting as to be useless, a too sensitive alarm that sounds whenever a regulation did not exist in an essentially identical form as the founding. Thomas's approach, she said, would be especially problematic in cases like the one at issue because it could not account for the sociological changes over time, given the fact that the law and the founding was more likely to protect husbands who abuse their spouses than offer some measure of accountability. She said it is no surprise that the generation did not have the equivalent of the law at issue here. Now, Justice Ketanji Brown Jackson echoed Sotomayor's disdain for the Bruen decision, noting that she too would have joined in the dissent if she had been on the court when the case was decided. And she argued that the majority's effort to clarify the Bruen test is a tacit admission that lower courts are struggling to apply the test. In her view, she wrote, the blame may lie with us, not with them. Now, Justice Amy Coney Barrett also pushed back against what she characterized as a requirement of overly specific analogs, describing serious problems that would flow from such a rule. It would, she argued, require 21st century regulations to follow the 18th century policy choices, given us a law trapped in amber. And it assumes that founding era legislature maximally exercised their power to regulate, thereby adopting a use it or lose it view of the legislative authority. Instead, she wrote, Bruen requires a wider lens that looks for a principle, although courts should not distill these principles at too high a level of generality. She noted that the majority has not done so here. Justice Gorsuch, on the other hand, appeared to agree with Thomas in taking a narrow view of what qualifies as a historical analog for purposes of the Bruen test. But he agreed that the early English and U.S. laws on which the majority relied were precisely the kind of historical analog that the federal government needed to provide. Gorsuch acknowledged that Thomas sees things differently, but if reasonable men can disagree whether the law at issue here is analogous to past practices originally understood to fall outside the Second Amendment scope, we at least agreed that the only proper question is that a court may ask. Now, the Supreme Court is currently considering other petitions for review, asking it to weigh in on the scope of the Second Amendment, including a challenge to an Illinois law and 3 municipal ordinances that seek to regulate assault weapons and high-capacity magazines, ammunition feeding devices that can carry more than 10 rounds of ammunition, and a challenge to federal laws banning possession of guns by people convicted of felonies, including nonviolent crimes. The justices could act on those petitions before they leave for the summer recess. And finally, our dumb criminal of the day. This is why you need to get gold from reliable sources, ladies and gentlemen. A pair of aged Floridians were swindled out of $400,000 in gold bars by a phone fraudster who claimed that the victims were facing an arrest due to illegal activity in regards to their Amazon accounts. A 78-year-old Jensen Beach resident called police to report that he had been bilked out of $154,000 after receiving a call from a man claiming to be an Amazon representative. After being told about purported fraud on his account, the victim was transferred to a Brian Alba, who said that he was an agent with the U.S. government and that based upon activity, there were several warrants out for his arrest. Mr. Alba said that he could keep the man out of jail, but the victim would first have to obtain $154,000 cashier's check and then used the funds to purchase 2 gold bars, each of which weighed a kilogram and about $75,000 apiece. Anyway, Alba assured the man that he would send him the cashier's check after he received the gold for the amount he paid for it. So after obtaining the gold, the victim put the bars in an old iPhone box and wrapped the package to make it look like a gift. With Alba on the phone directing him, the man drove back in May to a drop-off location and placed the package in the back seat of the sedan where the driver had the window rolled down. Well, the elderly man only called police when he continued to get calls from Alba seeking more gold. The victim apparently began to feel like he was being scammed. You think? Anyway, at the direction of the police, the man continued to take calls from Mr. Alba, who told the retiree to go back to the bank to move money from the investment account to his checking account so that he could get a cashier's check to buy more gold. Then the victim Thursday arranged to deliver an extra $200,000 to Alba's car, carrying a box filled with fishing weights, not gold. The man was told by Alba to drive to a nearby mall. There, the victim was directed to a Toyota where the driver was a male of Indian descent who was on the phone during the transaction as well. As the police surveillance team watched, the victim, as instructed, put the package in the Toyota, which then drove away with the gold, or the fishing weights. Anyway, the police subsequently pulled the car over and identified the driver as Teshkumar Patel, who carried an Illinois driver's license and said he lived with his family in Chicago. Anyway, Patel claimed he was in the U.S. since October of 2023 and that he has a green card. But after giving several false explanations, Mr. Patel was arrested for grand theft, a felony, and transported to police headquarters. Now, while in custody, Mr. Patel confessed to his role in the fraud scheme, saying that he had been paid by someone he knows only as Rocky to pick up the packages and then deliver them to the drop-off point. He claimed to have worked since May with Rocky, who pays for his travel, rental car, and hotel stays. Now, Mr. Patel, who claims that he has only done 6 jobs for Rocky, gave police access to his WhatsApp account, which showed that he had been sent all over the country by Rocky. His phone showed that earlier that day, he was directed to do a gold pickup from a 77-year-old Florida woman. Now, evidence in Patel's phone showed the driver picked up the 2 gold bars from the Jensen Beach victim in late May, and Patel pointed out that all of the people he picked up the gold from were Americans, and that everyone that he delivered the gold to were from India. Patel claimed he thought this was a little weird, but whenever he asked about it, Rocky told him to just focus on the job. Anyway, Patel claimed he didn't know the gold was obtained through fraudulent means. A police examination of Mr. Patel's phone revealed that he was allegedly involved in the scamming of another Floridian out of cash in the amount of $242,000 worth of gold. The swindle from St. Lucie County is expected to result in additional charges for Mr. Patel. Facing 3 felony counts, Mr. Patel is locked up in the Martin County Jail, and he has initial appearance in court this coming Friday. So, ladies and gentlemen, go to reputable places to buy your gold. If somebody is calling you, stating that they have a warrant for your arrest, but they can take care of it for a small fee of hundreds of thousands of dollars, it's probably Rocky or Mr. Patel, and guess what? It's a scam. Don't get scammed. Rocky and Patel are dumb criminals of the day. This stuff comes out and they get caught. All right, ladies and gentlemen, it was a big show today. I hope you enjoyed it. I hope you stuck with us through the entire time. Thanks for watching. We'll see you next time on Crime Talk.